Doctors are to traditional medicine what deal makers are to market opportunity. Lawyers are to injustice what deal makers are to adversity. Deal makers have a wide playing field. Deal makers quell fires. Daily, they experiment, fail, try again, differently, and get it done. They tap it. How do they do it? Hear it all in the Deal Makers Theorem, presented by Lawfinity Solutions and the Memo Recommended Lawyers.
Legacy litigation is a losing battle for corporate giants and startups alike. More than a matter of positioning, it's increasingly seen as a lost cause in light of insufficient documentation to support a faster resolution and insufficient resources to sustain it and derive any kind of a win. For general counsel seeing into the larger business goals and the complexity of the justice system, yet also front-facing the brand and its positioning, it is not a straight call as to what battle to pick and what to let go of. Swati Kamath, the General Counsel, Asia at manufacturing sector major GKN Automotives, draws upon her experiences across the consulting, manufacturing, healthcare sectors on the one hand, and her experience being a trained mediator from the Singapore International Arbitration Center on the other, to shuffle through the big question. So, how does Swati do it?
Thank you so much for showing up today for another episode of the Deal Makers Theorem.
Thank you, Prachi. Thank you for having me.
Walk us through your understanding of certain stakeholders and their motivations. And
In my case, what I have seen most of the times, it is ego. So one party doesn't want, they know they are on the wrong. They don't want a win-win situation. They know that they look bad if they compromise, or so they just want to fight it out, even if it takes the company's resources. If it takes time, the company's bleeding money, but it's just somebody's ego to deny. They don't want to say, yes, we made this mistake, let's settle and move on. I think this maturity is what is lacking, because of which we have so many disputes in courts across, not just in commercial or corporate, but even property matters and all. It's mostly just lack of maturity. So I think this is something probably that should be taught at school level. How to negotiation skills, having a win-win situation. Everybody wants to do business, right? Nobody's sitting here to lose money. So if one party has wronged the other party, I think it should be more than just a contract, or it should be the spirit of doing business, that we should make good the loss or indemnify the other party. Okay, we are wrong, so let's compromise and let's settle. So I think this kind of thinking is something that will help us reduce our disputes. Look at the bigger picture, look at the loss of business opportunities with that party. I have heard so many cases where SIMC was able to not only resolve the disputes through mediation, but on one hand they signed the mediation, and on the other hand they were signing new contracts for new businesses with the same party, because it's more forward looking, right? There's no point in looking behind, and you're never going to be happy with whatever. So one of the parties is always going to be unhappy. So it's always better to look forward and find a solution. So I think it's this basic tenet of maturity and being fair to the other party. I think this is what is missing. And I think the general counsels or the legal departments, or even the external counsels, play a very important role here, because they can advise the management saying, listen, these are the loopholes, or these are the weaknesses in your case. So you might want to look at this a little more, in a little more better way, instead of just being so aggressive or wanting to litigate or sue the other party. So I think bringing more compassion and being a little more fair is
also, from your experiences, what kind of financial bleeding, what kind of figures are we looking at with some of the legacy litigations?
Yeah, so I mean, JV disputes or any litigations which have criminal consequences, obviously the lawyers are more expensive. Again, it depends on the types, right? If it's a labor litigation, the costs are relatively lower. A case for wrongful termination could go on for years, but that wouldn't, cost me so much as an environmental matter, or a JV dispute where there's a criminal consequence. So again, and more than anything, it's not just the money, right? It's also the time. The time that the legal department and the other ancillary departments who are supporting the legal department with documents are spending on this. And that you can't measure that. So that's a bigger loss, I feel, which is why I say that, it's always good to put an end to these legacy litigations, settle where possible, or just withdraw the case and close it if it doesn't make sense.
In terms of legacy litigation, what are the various categories that you see on and on in this sector?
Yeah. So I think, without offense to our judges, I would like to say that in India, I think almost every litigation is a legacy litigation, because it just takes so many years for these litigations to actually come to a fruition, that whether it is a simple civil recovery claim, or it is a complex JV dispute. Take the labor litigations, for example, IP matters, real estate matters, tax, customs, environmental compliance, contract breaches. I mean, any simple to complex, matter takes at least 3 to 5 years, on the lower side of, there's no time frame. That's the problem, right? Our courts don't have a time frame to complete, a dispute. And then, of course, we have an appellate system set up. So that is the reason. Also, the procedural complications that we have in our CPC and CRPC just makes everything so lengthy and so complicated, that almost every type of litigation that we touch upon ends up going on for years. Judges change, we in-house counsels change, the management of the company changes, but the matter is still going on. In the process, we also tend to lose out on evidence, on documents. The record keeping may not be great everywhere. So that again leads to a further delay, or a further prolongment of the case, and a lot of other issues that the government needs to look at. We have a lot of frequent legislative changes, especially when cases go on for 10-15 years. The law changes in the during the process so many times, and then you keep fighting for retrospective applicability. Another thing which I feel is missing in India, and is probably prevalent in Europe and some courts in the US, is performance metrics for judges. So on what basis do we judge judges? The quality of the timeliness, the quality. I think everything is important, right? It's obviously without compromising on justice. But there needs to be some performance metrics, because there's nobody questioning them. Also, what I have personally, experienced is that judges get transferred so frequently. And even the new judge who comes is not even a subject matter expert. So in a labor court, there are civil judges coming, or even criminal court judges coming in, and they have no subject matter expertise. So they themselves want to delay the matter. They are not interested in, really getting into the nitty-gritties. They're just waiting for their transfer, to a court where their skills are more relevant. I think so. The government also needs to see how to make this, how to make judges, the position for judges, more lucrative, or more incentivizing, because people prefer to be lawyers, rather than judges.
Is there anything, Swati, that you would like to see a gap addressed, or how the communication channels are maintained, or the strategies being used? Would you want to see some particular area of improvement?
In India, predominantly, what I see is that, people like to keep other people engaged in litigation. Like, let's keep them busy with litigation. That I don't think that's a good strategy, because you are bleeding money. So that's one. I think that's, like I said, there's a lot of mindset changes that need to happen. Training to employees is very important, which is in the control, which is in our control. I can tell you 10 things the government needs to change, but I think at a corporate level, what we can change is give training on communication, etc., which will prevent. So more preventative measures. How do you prevent conflicts from escalating into disputes? Also, policies and processes in multinationals are not so much of an issue. They're already there. I think what we need to do is upgrading our systems, and if we see any loopholes in these systems, resolving those. Like, for example, in one of my previous companies, we had a system which would send it's not a purchase order, but it's called a schedule order. So it doesn't have the terms and conditions attached. And we did not have proof that we had actually sent out the main PO. We were not able to prove that, because the system sends out the PO initially. And after that, it just sends these schedule orders. And the PO contains the TNCs, which contains the arbitration, etc. And this system does not maintain a record of what it sends out. So we were not able to prove that the other party had actually received the PO. And because of that, we could not arbitrate a dispute. Just because of a system issue, that cost us, a lot, because we couldn't arbitrate the issue. So another thing we can do is we should encourage ADR, ODR, these alternative dispute resolution mechanisms such as mediation, arbitration, because it's time bound, it's cost friendly. For smaller disputes, it helps preserve the relationships. And like I said, we should encourage early settlements, early dialogue. Uh, I think these are some of the simple things. And also just keep reminding employees whenever they go to the legal department, to file a case or to send a legal notice, is that we are here for to do business. We're not in the business of litigation. So let's use litigation only when absolutely required. It shouldn't be your first resort to resolve a conflict.
It would be worth some understanding of what are these conflicting, clashing interests, where now we understand some more about stakeholders and their interests, and which we can communicate better.
Maybe in the interest of one party to delay a matter. The lack of historical data, because it is going on for so many years, and you're asking for data which is 15 years old, the company may not have it. So again, there's this interest in dragging the matter for long. So I think courts also need to be a little more practical, looking at their what data they're asking for. Is it even possible? In a recent matter, courts asked us for data which is around 10 or 12 years back, asking for how performance was graded at that time. And this is for the shop floor employees, right? So HR doesn't have that data. That 15 years back, how we graded, what was the performance metrics, on what basis would we give increments and promotions. We don't have that data documented, 15 years back. So I think some practical aspects which even courts need to consider. So I think for manufacturing or any sector for that matter, I think communication is very key. So something that I encourage my stakeholders is to document. They have verbal discussions with the vendors or customers, and it may be a commercial term, but it's not put in writing. Even an email exchange where one person says, okay, this is what we discussed, please share your confirmation. Even that is helpful. But sometimes we miss doing that, and then there's a dispute. So most of the times I've seen disputes arising out of poor communication. So yes, that's definitely very important. Another thing, draft unambiguous contracts. With I ensure that my contracts are in simple English, which business can understand, which the other party can understand, because we are dealing with people from different countries, and we want them to understand. It should not be the impression that contracts are meant only for lawyers. So I also encourage, in fact, I push my business to read the contracts, because they need to know what are their obligations. And if they don't meet those obligations, what are the damages or penalties that the company has to pay. So it's very important that they read. They kind of tend to push it on legal, saying, can you review this? But if you see a contract, it's only 20% legal, 80% is commercial. So getting them to review the contract along with me is something that I very strongly follow. Another thing is, I am also a trained mediator from Singapore International Mediation Center. So I also, encourage dialogue. I encourage, if we can resolve the dispute or the conflict before it escalates into a dispute, by discussion, and then, have a med arb lit kind of, dispute resolution mechanism in our contracts. So I first try to understand the strength or the weakness of a case, and accordingly advise business that, because sometimes even if your case is strong, it just doesn't make sense to litigate for another 5-6 years. You've also killed the relationship, the business relationship with that third party, and that could be a critical third party for you. So sometimes you have to look at the bigger picture and then take a call, rather than just look at the legal strengths of your case. Also encouraging early settlement discussions in especially non-critical matters helps before it escalates. When the losses are not mounted, the damages are not that great, the pressure is less on both the parties. So I think the atmosphere to negotiate is also more amicable, and it's easier to think logically rather than emotionally. And I think lastly, what is important for business is to paraphrase. A lot of times intention is misconstrued. You say something to me on email and I say yes without even really understanding what that means. So I think it's very important that we paraphrase what we have understood, and we say that, okay, can you confirm my understanding is correct? So this also helps in preventing a lot of unnecessary conflict in future.
Really interesting way to think about it phase wise, that okay, first of all focus on good communication, paraphrase it, then also if it starts getting adversarial, control it at the time when emotions are not peaking.
But commonly, this is what I put in my contracts, because mediation is, more informal. And like I said, from a business perspective, for me, what is critical is saving the relationship. When you litigate or arbitrate, the relationship gets killed. Because it's more adversarial in nature, whereas there is more dialogue, and this is actually, mediation is nothing but two people coming together, and the mediator is only pushing them towards a mutual settlement or a mutual solution. The mediator doesn't pass any order. So they, he's not making any decision there. He's only getting them to speak up, to come out with their pain points, come out with solutions, get them to, mutually resolve so that they can get back to business. That is why my first preference is mediation. If mediation fails, then I would go into arbitration, because again, arbitration is time bound. And also that again limits my costs, because it's a time bound process. And if not, and then again, I have a lot of being a general counsel for Asia, I have a lot of cross border contracts. So for me, more than litigation, I prefer these ADR mechanisms. And then if nothing works, of course, the courts.
Also something that you would want to see when you're engaging with external counsel in terms of how the billings are presented to you, or anything
Yeah.
on strategies or anything, any such gaps.
Yeah. So I think, anyways, now because of the cost pressures internally, we are also using external counsels very sparingly, only where we're required. In smaller companies, especially where there's a legal department, we don't really engage lawyers on retainership basis. It's more assignment basis. So I always appreciate having a fixed cap, fixed cost cap rather than hourly billing. And also, it has to be a reasonable rate that is being charged, because some lawyers can charge a bomb. I also, I don't prefer working with celebrity counsels, because it's really expensive, and I think there is more press and more media attention to these cases. So there are a lot of competent counsels out there who work at reasonable rates, and who are have a similar mindset of a win-win. They don't want to kind of fleece you. They want to do a good job and do it at a reasonable rate. I like to work with such external counsels. So I think that's important, to have some quality counsels on your panel, who understand your business needs, your budget limitations, and are ready to work around those.